Hello everyone, I'm Alex Grant and welcome to Immigration Update Desk. Over the last couple of weeks, you've probably seen a wave of alarming posts about a so-called new visa ban, sudden travel blocks, and claims that green card holders may no longer be safe to travel in 2026, and I know how that feels. Your feed fills with dramatic thumbnails, friends forward clips out of context, and before you know it, you're wondering whether to cancel flights, pull kids out of school, or abandon a case you've been building for years. That is exactly why this breakdown matters right now. Because when immigration policy shifts even a little, misinformation spreads faster than the actual text of the rules, and not every headline reflects the full picture or uses the legal terms correctly. So instead of speculation or panic, we're going to walk through what has actually been ordered regarding visa bans and consular pauses in early 2026. How those actions interact with existing rules, what they mean for green card holders and current visa holders, how they affect people applying abroad versus people adjusting status inside the United States, and how to make smart choices while the policy dust settles. To set the stage, the key context is an expanded travel restriction that, according to official proclamations issued late in 2025, took effect on January 1, 2026, and builds on earlier travel controls by broadening the list of countries whose nationals face tighter limits on entry and visa issuance. The stated rationale centers on national security and public safety screening, and the functional effect is this. Foreign nationals from designated countries who are outside the United States on January 1, 2026, and did not hold a valid U.S. visa on that date are subject to restrictions on entering the United States and, in some cases, on receiving a visa until they qualify for exceptions or waivers under the policy. There are 2 points that many posts miss, and they should calm the conversation a bit. First, existing visas are not automatically revoked just because the proclamation took effect. And if a traveler holds a valid visa that was issued before the effective date and otherwise meets admissibility rules, that visa can generally still be used to enter the United States. Second, the ban does not apply to people already inside the United States on the effective date, and lawful permanent residents, green card holders, are not stripped of status by a travel proclamation. Green card status endures, and LPRs retain the right to re-enter if they carry proper documentation and comply with long-standing immigration rules about identity, admissibility, and maintaining residence. The expanded list covers both immigrant and non-immigrant visa categories for nationals of the designated countries, which in practical terms means that someone from a covered country who is outside the U.S. and planning to come to live, work, study, or visit now faces stricter eligibility, enhanced security reviews, and sometimes redirection to posts equipped to handle the extra screening. That's the first pillar of this moment. The second pillar is a separate State Department directive, reported on January 14, 2026. Instructing consular posts to pause the issuance of new immigrant visas for nationals of 75 countries while screening procedures and public charge standards are reevaluated. This is not the same document as the travel proclamation, though there is overlap in the countries. Under the pause, consular sections have continued to accept filings and even to conduct interviews in some cases, but officers are instructed not to print or issue immigrant visas to covered nationals until further notice. Importantly, the pause targets immigrant visas, that is, the consular pathway to a green card, and does not apply to non-immigrant categories like B1, B2 visitors, F and M students, J exchange visitors, or H-1B and other work visas, which, unless separately restricted, continue under standard procedures. So if you have a cousin applying for a tourist visa or a student seeking F1 from a paused country, those cases may still proceed, whereas a spouse awaiting a CR1 IR1 immigrant visa may find the interview is held, but the passport is returned without a visa pending further instruction. This is why friends in the same family can have completely different experiences in the same week. Now let's translate that into what it means for you if you hold a green card, already have a valid visa, or are waiting for one. If you are a lawful permanent resident, the broad rule has not changed. Your LPR status remains valid, and you are generally exempt from the entry restrictions of the expanded travel proclamation, so you can still travel and re-enter so long as you maintain documentation and meet routine admissibility rules. Exceptions are rare and typically involve unrelated legal issues like certain criminal convictions, evidence of abandonment of residence after long absences, fraud findings, or prior orders, not the travel proclamation itself. If you are a non-immigrant or immigrant visa holder with a visa stamp issued before the effective date, that visa is not auto-canceled by the new rules. Instead, you present it at the port of entry, and CBP officers apply the usual admissibility review. As always, any traveler can be refused at the border if they are inadmissible for reasons in the Immigration and Nationality Act, but that has been true for decades. What's different is that screening for designated nationals may be deeper or slower, so expect more questions, be honest, and carry supporting documents that show ties, purpose, and compliance with your category. For visa applicants outside the United States, the challenge is timing and patience. If you are from a designated country and did not hold a valid visa on January 1, 2026, you are likely to face enhanced screening, and for immigrant visas, the State Department pause means consular officers may not issue your visa until the review is complete. If you are from one of the 75 countries listed in the immigrant visa suspension instruction, even an approved I-130 and a documentarily qualified National Visa Center file will not immediately lead to a printed visa. In that scenario, the best moves are to keep your CEAC record clean and current, retain valid police certificates and passports per the reciprocity schedule without jumping so early that documents expire, and monitor your embassy's announcements. If you have already attended an interview and received a 221G slip, follow the instructions precisely, submit exactly what is requested, and keep records of every exchange. Because when issuance resumes, the cases that are administratively tidy will move first. If your case was not yet at interview, stay in touch with the NVC through the public inquiry form if your documents or addresses change. But do not spam the system. It won't speed anything up. A major piece of anxiety right now is the phrase public charge. So let's demystify it. Public charge is a long-standing ground of inadmissibility focused on whether someone is likely to become primarily dependent on certain government benefits. And while policy details have shifted over the years, the current review places added emphasis on financial self-sufficiency and accurate sponsorship. In practice, Consular and USCIS officers look closely at the Affidavit of Support package, Form I-864, signed by the petitioner, tax transcripts, W-2s, or 1099s, proof of current income, and evidence of U.S. domicile. If the sponsor's income falls short of 125% of the federal poverty guidelines for the correct household size, 100% for certain military sponsors, a qualified joint sponsor can file a separate I-864, and in some cases, liquid assets can cover a shortfall if they meet the required multiple and can be converted to cash within a year. Poorly filled I-864s, wrong household math, unsigned forms, and year-old tax PDFs instead of IRS transcripts are among the top reasons NVC kicks a case back for correction, and every resubmission restarts the review clock, which is especially painful during a pause. The takeaway is that even if visa printing is paused, you can use this time to get sponsorship evidence rock solid so that when issuance resumes, the officer has no reason to hesitate. Because people are hearing ban and suspension in the same sentence and assuming every door is closed, let's separate scenarios through a few clear examples without changing any personal data. Imagine a U.S. citizen who filed an I-130 for a spouse abroad. USCIS approved the petition, the NVC marked the case documentarily qualified, and in December 2025, the embassy scheduled a January interview. The spouse attended. The interview was otherwise fine, but the post returned the passport with a 221G letter stating issuance is pending, while immigrant visas for nationals of the country are paused. This does not void the approval, it just defers visa printing. The right move is to keep paperwork current and wait for the post to announce resumption. Now imagine a green card holder who traveled to see family and is returning in February 2026. They carry an unexpired green card, a valid passport, recent U.S. pay stubs, a lease, and last year's IRS transcript. CBP refers them to secondary for routine questions about length of absence and ties. After verifying residence, they are admitted because LPRs are not the target of the proclamation. Next, imagine an F1 student from a covered country with a valid F1 visa issued in 2025 who is returning for spring semester. The proclamation does not invalidate the visa, but the student should expect extra screening. Carrying an I-20 with a fresh travel signature, tuition payment receipt, and proof of enrollment reduces questions. Finally, consider a would-be visitor who had no visa on January 1st, 2026. They apply for a B1, B2 now. Whether they can receive it depends on whether their country is on the proclamation list for non-immigrant restrictions. If yes, issuance may be limited or require a waiver. If not, the case proceeds under usual standards. This is why reading primary sources and post-specific guidance matters. For green card holders specifically, the safest approach during a period of heightened scrutiny is to travel with a reentry plan. Carry your green card or an unexpired I-551 stamp if your card is in renewal, a valid passport, evidence of employment or school enrollment, proof of U.S. residence such as a lease, mortgage, or recent utility bills. And if your trip will exceed a year, apply for a re-entry permit before departure so you can remain abroad up to 2 years without risking an abandonment finding. Even trips under 6 months can attract questions if your pattern looks like residence elsewhere or if you filed taxes as a non-resident. IRS transcripts showing resident filings help. If you have any criminal history, even old misdemeanors, consult counsel before travel, because immigration law treats some offenses more harshly than state records suggest. Do not sign a record of abandonment, Form I-407, at the border in a moment of panic unless you intend to relinquish LPR status, and do not carry inconsistent identities across documents. Name order, diacritics, and birth dates should match or be explained with official records. For families caught by the immigrant visa pause, planning is now measured in months rather than weeks. Keep medical exam timing in mind. Most immigrant medicals are valid 6 months, and if issuance is paused longer than that, you may need to redo the exam when interviews restart. Keep police certificates within validity windows per the reciprocity table, and if your country's police certificate is considered unavailable, ensure your CEAC upload includes the correct note or alternative. If the beneficiary resides lawfully in a third country with a more open post, consider requesting a case transfer with proof of residence and local status, understanding that transfers introduce their own delays. If hardship is acute, gather medical letters, employment letters, or school documentation to support a humanitarian expedite request when the post begins to process exceptions. Verify every step through official channels to avoid scams. Guaranteed expedite offers proliferate when people are desperate. For applicants inside the United States, adjustment of status has not been frozen by the consular pause. If you are eligible to adjust, you can file I-485 with I-130, where appropriate, add I-765 to obtain work authorization and I-131 for advance parole, and move through domestic processing. Expect more detailed interviews in 2026 because officers are documenting credibility and eligibility more thoroughly across the board. But approvals for genuine cases continue. Plan your timeline realistically. Biometrics reuse notices may arrive without a visible appointment. Online case status updates can be slow, and some field offices are more backlogged than others. If you rely on an EAD for work, file renewals at the opening of the window and keep your HR team informed so I-9 re-verification can be scheduled. If you must travel, do not depart without approved advance parole unless you are in one of the limited dual-intent carve-outs like H-1B or L-1 and traveling under those rules. Leaving without AP generally abandons a pending I-485. If you are pursuing naturalization, watch continuous residence and physical presence. Trips of 6 months or longer can interrupt continuous residence unless you can establish otherwise with strong ties and explanations, so a cautious travel plan is smarter than a risky one during a policy-tight year. It's also wise to tackle myths head-on so they don't control your choices. One viral claim says visas and green cards are being canceled overnight, which is not how the law works. Existing visas are not automatically voided by a proclamation, and permanent resident status is not canceled by a travel policy. Another claim says immigration is frozen, yet USCIS continues to accept and adjudicate petitions and adjustments, NVC continues to review documents, and consulates continue to process non-immigrant categories subject to normal demand and security checks. A third states, green card holders can't fly domestically, which confuses TSA identity checks with immigration enforcement. TSA verifies ID, not status, while CBP or ICE may conduct operations in some airports. Domestic travel with valid ID remains lawful, though those with prior orders should discuss risk with counsel. Finally, some insist public charge means you need a high salary to immigrate, which oversimplifies. Public charge determinations rely primarily on the sponsor's affidavit and a totality of circumstances assessment, not a single salary threshold for the immigrant. What should you do this week if your family is affected by the travel proclamation or the immigrant visa pause? First, verify your category and your country's status using official sources, your embassy's alerts, State Department pages, and, where applicable, a primary proclamation text. Second, get your documents immaculate. Tax transcripts for the sponsor, a clean I-864 with correct household size and signatures, current civil documents that match reciprocity requirements, clear scans labeled by document and applicant, and a simple index so you can resend quickly if asked. Third, build a calm communication plan. Check CEAC and email on a schedule rather than hourly, store all correspondence, and use the NVC public inquiry form only when you have something material to report or your case is outside posted timeframes. Fourth, plan finances for re-medical exams or travel changes and avoid non-refundable bookings until you hold the visa. Fifth, for LPRs and current visa holders, plan travel with conservative assumptions, carry ties and identity documents, and memorize a trusted contact number in case your phone is unavailable during secondary inspection. Sixth, if your situation is unusually urgent or complex, consult a qualified attorney for a tailored strategy rather than relying on generalized advice online. Stepping back, what we are experiencing in January 2026 is a period of expanded travel restrictions for designated nationals and a temporary consular suspension of immigrant visa issuance for a wider set of countries, both framed as measures to increase screening and vetting especially on the immigrant side. This is not a blanket ban on all lawful immigration, it is a tightening of certain gates. The details matter, and understanding how proclamations, consular pauses, and long-standing rules interact is the difference between costly missteps and a steady path forward. Immigration Update Desk will keep tracking official announcements and translating them into practical guidance for green card holders, visa applicants, and families around the world. And in the meantime, remember that lawful permanent residents continue to re-enter with proper documentation. Many non-immigrant visas continue to be issued when eligibility is proven, and temporary policy measures can be modified, narrowed, or rescinded through legal challenges, administrative revisions, or new executive actions. The smartest thing you can do is stay informed through primary sources, keep your case organized, and avoid panic decisions that create bigger problems than the policies themselves. As always, our goal here is clarity over clicks. If this helped you cut through noise, subscribe and tap the bell so you see updates as they post. Share this with someone who needs a calm explanation. And know that even in a stricter year preparation, honesty and patience still lead to approvals. This content is educational, not legal advice, because individual facts matter and immigration law is complex. For case-specific questions, consult a qualified professional. Thank you for watching Immigration Update Desk with me, Alex Grant, and I'll see you in the next video where we walk through how to keep a consular case interview ready during a pause, what to pack for an LPR reentry in 2026, and how to verify any viral rumor in under 5 minutes so you never change your life based on a headline again.